Hey everybody, we're live, coming in everywhere for Facebook pages and live on YouTube. What's up? Tonight we're going to talk about some cool stuff. So one of the things we're going to talk about tonight is we're going to discuss the non-judicial foreclosure process. But before we get to all of that, welcome back, Advocates for Justice, Foreclosure Defense Paralegal Service. We are different and we prove it. I'm Coach Neighbors. You guys know who I am. I'm the guy to get to blow the whistle up in here. And today we're going to cover the non-judicial foreclosure process. We're going to review how to attack it, how to block the eviction process, how to remove the eviction process over to federal court from state court over to federal court to be connected with your title dispute. We'll talk about that. I'm also going to showcase the new lawsuit package that we are using against the judge for illegally dismissing your jurisdictional challenge with an affidavit. And that package has like 6 documents in it. So before we get started, I want you guys to click the bell down below and to make sure that you subscribe so that you will be able to get notifications when we're ready to rock and roll, when class starts. And also please leave comments. That lets YouTube know that you find value in what I'm doing here. So welcome tonight. And let me check. I see we got some people already here. Took me a minute to get up and rolling. I was having a little bit of an issue, but then I figured out it wasn't the equipment that was the problem. Anyway, that's my story and I'm sticking to it. So welcome. There you go. Got a couple of comments. Hey, Connie and Dylan Shea and Carrie Jackson. What's up, you guys? Tonight we're going to rock and roll. So we're going to get started. And those who come in after we get started can just catch up. They're going to be put on the B team, or maybe they might be on the bench for a little while. So let's just get right into it. The non-judicial foreclosure process. Now, when I set up these lawsuit packages, I went through the judicial foreclosure problem, and that's years ago, and that's when I started doing all this. When I set up the lawsuit packages, I had the package for the judicial and the package for the non-judicial the same. I did not realize there was a slight difference in the fraud. And people were struggling because they filed their lawsuit. And if they were close to the date that they were going to kick them out, all of a sudden federal court would put their lawsuit in a basket and leave it sitting on a thing and start stalling, giving the people enough time to try to get the eviction process done. So, hey, John Castro. So we'll take questions at the end, John. So I know you got a couple of questions more than likely than not. So welcome to the group, buddy, and listen and learn. So the foreclosure, the non-judicial process, and I had to do a lot of extra research to be able to structure the non-judicial package in a manner that would help people, because I'm not trying to be like attorneys and just sell you something and then not care whether it helped you or not, or not caring whether or not you got the value out of it you was hoping to get, or not caring whether or not it protected your property. Or not, okay, you got it, right? Okay, so we're gonna move on. So I had to go back to the drawing board and restructure the whole non-judicial process, because obviously in the beginning didn't understand the fraud that was involved in it. Now, the non-judicial process, and this is my opinion based off of all of the research that I've done over the very long period of time. I hate to put a time on there or what state I'm talking about, because ain't nobody's business. I know there's haters listening and trying to figure some things out. So I went back to the drawing board and started with the non-judicial process from scratch, and I started reviewing it. Now, For me, I already know that their whole program is based off of fraud. So it's easier for me to see stuff because I already know that everything attorneys are doing, every time their mouth moves, they're lying. So I'm looking at it from a different perspective than the average person who believes that everything is fair and we have rights and blah, 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 blah. Okay, so that's the best way I can put it. So when I'm looking at things, I see things in a little bit different fashion. So I started reviewing the non-judicial foreclosure process, and I could not understand how the hell they could get away with what they're doing because the Constitution mandates that before they take your shit, you're supposed to be and have some due process of some stuff and all that stuff. You know what I'm talking about? Where is all of that? Well, we're going to figure out how to get that in the program. So I started looking at this process, and what they're doing is they're using a clause in the alleged contract to foreclose on you once you're in default. And most of the time when they're using something like that, you have to like initial it to verify that they pointed it out to you. But that's not what they do. They don't do any of that stuff. And I think they get away with a lot of crap because the higher attorney ain't going to rat on his fellow attorney snake slime. So that's how that goes. They ain't going to do anything to attack each other. So what we found out, and this is my opinion based off of the research that I had to do to understand how to attack this non-judicial foreclosure process. In my opinion, the non-judicial foreclosure process was put on the books as a way to process the property once the homeowner's up and left. Think about it. The Constitution mandates that you were supposed to have due process and go through court before they can do all these things. But what do you do when people just walk away and leave? So to put this clause in the contract in the deed of trust or the mortgage contract or whatever that they can foreclose if you. And what started me on looking into this particular part of the situation was the fact that some states have both. Some states have non-judicial foreclosures and judicial foreclosures, and then they say, well, it's mostly judicial or mostly non-judicial. Okay, that's just creepy and fraud. It either is or it's not. How the hell could it be both? Well, then the more research I've done, then it started pointing to the fact that they put this process together to do a foreclosure when people left. And as we know, as they know, we don't know shit. So they just started using it as a way to get around everything, get stuff done a whole lot quicker. So we're going to talk about that and how you want to attack it. Now, the first thing that they've done is they've meshed everything together and they moved it around to different courts, the non-judicial foreclosure process. And so actually, there is no non-judicial foreclosure process in the court. Okay, the whole process is done outside of the court. You don't get in the court until the eviction part of the process starts. So I wonder why they even waste their time with this. Okay, well, we won't go there because at least that's where we're going to have a chance to nip this crap in the bud. So they meshed it together and they moved the eviction process down to a lower court that does not have jurisdiction to hear anything, a title dispute. And once I figured out that the lower court does not have jurisdiction to hear a title dispute, and the title dispute would be a lawsuit against the title of the property. You with me now? So when you create your title dispute in federal court by filing that lawsuit for wrongful foreclosure / breach of contract against the attorney that actually signed to initiate the foreclosure against the property, when you file that lawsuit, you create your title dispute. And see, here's the thing. With in eviction court, the only thing that the judge can make a ruling on, well, the whole thing is illegal, but we're just going to go I'm going to speak from their process, okay? Because the judge can't make a ruling on none of it because it's illegal, but we're going to go from their process so I can make the point. The only thing the judge can make a ruling on in eviction court is immediate possession. The whole process is fraud. Immediate possession is the only thing the judge can rule on. So the new buyers come in with the new attorney that's friends with the attorney that actually attacked your property, and they come in with their little release of deed that they just got from the clerk of the court or whoever it is that signs that illegal crap for them. And now they are going to prove to the court that they are the holders and demand immediate possession. They're the person they have standing to demand immediate possession and kick you off the property. Now, the eviction court ain't trying to hear none of anything that has to do with the title dispute. The title dispute is a problem with the title to the property. And if you file your lawsuit in federal court, now you trump all of their stuff because now you have a title dispute on the record, and that court cannot hear a title dispute. That's the key. That is the key to kicking the eviction court's butt in a non-judicial foreclosure. But you have to create the title dispute, and you have to get the title dispute filed in federal court. And we'll go over the process of how you do that here in a little while. So once you create your title dispute in federal court, then you can move the process from eviction court over to federal court to be connected to your title dispute. And we have the documents in the lawsuit package to do that. I have people in the group that have done that and are doing that right now. And everybody is running around worrying about case law and how to take this case law in the court. And I had a lady ask me the other day if I can provide her with, she's heard great things are happening in our group, and she wanted me to provide her the case law to the people who have fruit jailed their case or whatever, won their case or whatever. So I just explained to her, number one, I'm not the one doing it. I don't have their case law. I don't have that stuff. The goal of what we're doing is helping people learn how to do it themselves, number one. And number two, there's no winning. If you're going to go into court and you're going to go into court during their conventional foreclosure process, you're doomed. Okay? People forget that the conventional foreclosure defense process was structured by the same attorneys that's trying to steal your shit. People forget that. So if you go in doing the conventional thing, arguing the banking system and asking to see the note and all of that stuff, you're just going to get hosed, just like all the other people that are getting hosed. We have to figure out a non-conventional program. Otherwise, we're going to be doomed. And that's what we've been working on. And I've been structuring this program for a while now with the help of all of the members in our Facebook group and a few other people, but mainly the members in the Facebook group. I have members in our private rescue and our foreclosure rescue private Facebook page from California all the way to New York. I'm not kidding. We have members all over the place, and the real-time feedback that I get from those members in the group is what helped me structure the program and change things and add stuff, and to make sure that the people on the other side of the country and in the middle of the country aren't allowing the attorneys to use the same crap that the people are using on the West Coast or vice versa. And we've been able to build a pretty nice little program here. Now, I don't have all the answers, but we're figuring out some of them. We got people that started in my lawsuit pack and my lawsuit program using my lawsuit packages. Let me see, before last Christmas, and they're still in their house. They're still in their house. Now, our goal is not to go to court and get the judge to give you anything, because that's never going to happen. And that, to me, is what people mean when they ask how many wins, or whatever. That's never going to happen. Our goal is to make them stay in court, cost them money, and build your record that you're going to need to sue the judge with, because the judge is going to have to help them. If you come to the table with my fire, the judge is going to have to help them. And that's what we're seeing happening. And that's one of the things we're going to talk about as a new lawsuit package that will put together to address that problem. But we'll talk about that a little bit later. So when all of this takes place, they get away with this. And it's pretty easy for them because people don't realize your due process, that people don't realize that the due process must be filed when you file your lawsuit in higher court. The due process must be granted to you when you file your lawsuit in higher court. And that lawsuit being filed in higher court is what you're going to use to control the state court process. And if you stop and think about it, just filing it in higher court is going to cause the state court to have to step down and step aside. And they'll try not to. And we have a program for that too. When you add the party who signed to start the foreclosure against your property to your lawsuit as the number one defendant, you will be driver of the bus. And if you look at your paperwork that was filed against you, or the notice of default letter, if you're in a non-judicial, that notice of default letter is always signed by the attorney. And I had one lady told me, no, the assistant to the trustee signed it. No, the attorney signed it. The attorney signed it acting as a third-party debt collector. There's no trustee involved. There's nobody from the bank involved. It's just, well, actually, I take that back. There are a lot of players involved behind the scenes after they take your stuff, that they all get part of the money. But there's nobody involved in the actual foreclosure against your property. That person that signed that is the person that you need to hold accountable. Now, what we've been learning how to do is run the same plays on them that they've been running on you. But you trumping their ass by moving your stuff into a higher court. And I learned this playing football. I played for the University of Kansas in 80 and 81, and we played against Nebraska 2 years in a row. And back in the 80s, Nebraska beat the crap out of everybody. Yeah, they beat the crap out of me too. So I don't have a problem. I don't have a problem saying it. Yeah, but I learned. And one day I heard my coaches talking in between halftime. They were really pissed. And they were pissed because Nebraska came to play on our turf, and we spent all week studying their plays and stuff and being ready for their plays. Well, they came up in here and they ran our plays down our throat. Yeah, that struck me. They ran our plays down our throat. Boy, that's a statement. So that's what we're learning how to do. We're going to learn how to run their plays down their throat and stick it down their throat, up in their face. That's how I say it. That's what we do. They have so many holes in their program because their program is built off of fraud. And we're going to teach you how to take advantage of that. So when you add them to the lawsuit as the main defendant, it would be a huge problem for the attorneys, because most of the time the non-judicial process is done by a group of the same players. And in one state, I won't mention the state's name, but in one state last year, well, it's this year, but at the beginning of this year, we had 4 team members from the group with the same attorney trying to steal their house. Yeah, that was funny as hell. And we enjoyed that. We was driving that man. I don't think he had any hair by the time it was over with. And to my knowledge, people are still in their house. People need to understand that these attorneys, when you back them up in the corner and make them not want to have to go into court and not want to cut and do, when you make them not want to, they just go walk away. They walk away, or they work out some kind of a deal, and then people sign a disclosure statement and can't tell me about it, which is fine with me, because my number one goal is to help you learn how to stay in your house. That's the number one goal. And I tell people, and people tell me, well, if I said that, I tell you, you know what? If you can work out something to get to stay in your freaking house after going through all of this shit, you better do it. I'm not worried about being able to tell people that you're still in your house or show stuff. I don't have time for all of that. The way I roll is, if people can't figure out the value and see the value in what we're doing, they don't need to be in my program, because I would spend too much time arguing with them, trying to convince them to do what they need to do to get this done. And when I say too much time, what I mean is People who believe that the way the attorneys do things and all of that, they have a hard time in my program. Well, number one, because you're going to an attorney. But number two, they have a hard time doing things different. They have a hard time. And I don't know, it drives me crazy because I'm like, okay, let's keep it simple. What you're doing freaking ain't working. So what else you got to do? You can't just keep doing what you're doing that ain't working. Okay, let me settle down. I'm getting worked up. So that's the way that rolls. So a little to know about the non-judicial foreclosure process. The main thing that you want to do is put yourself in. So in non-judicial, actually in either the non-judicial or the judicial, but the judicial process is not really that important to think about this for most people because you have a lot of time, unless you squandered all of that time sitting around waiting for the case law to come to show, okay, you see where I'm going with that. Let me stay focused. So blocking the eviction process is, to me, the most important part of your strategy for foreclosure defense. Okay, blocking the eviction process. Now, what I mean is you need to learn how to stay in your house. And blocking the eviction process, particularly in a non-judicial foreclosure strategy, is the most important thing. Because they know if they get your butt kicked out, you're not going to be able to fight them because you're going to be too busy trying to figure out where the hell you're going to have your family, what the hell you're going to do. You don't have access to internet or your stuff. They know that. So in a non-judicial foreclosure defense strategy, the most important thing is to have a game plan to block the eviction process. And what we do is when you get an eviction court, if you have my package, then what you're going to do is you're going to file the challenge of jurisdiction, the eviction court jurisdiction that's in that package. You're going to file that in eviction court. And then you're going to take a file stamp copy of what you just filed in eviction court to challenge the eviction court jurisdiction. And please, do not give the judge a chance to answer. We don't want the judge to answer to anything. People forget and sit around and wait for the judge to answer, and the judge is going to throw you on the bus and screw you. So we're not waiting for the judge to answer. Okay. In my program, you the judge, so you get to do the answering. That's the way we roll. So the eviction process, what you need to do is you file your challenge of jurisdiction, challenging the eviction court's jurisdiction, based on the fact that, and I'm just going to lay this out there for you guys, okay? Because if you already fighting and you already know enough of this stuff that you can take what I'm saying and apply it to your situation, rock and roll, because that's what my channel is all about. If you need help, we got the documents that can help you and the group coaching. So the eviction process, you challenge the eviction court's jurisdiction with the document that's in the package. And then you take a file stamp copy of that motion challenging the eviction court jurisdiction, and you attach it to your notice of removal. The notice of removal you take over to federal court, and you file it in your case in federal court. You put the case number on there, whatever, and you tell them, hey, I need you to file this immediate possession issue in my title dispute. If you use those words, they would be like, what? I'm serious. Here's the deal. The immediate possession cannot be determined by a court until the title dispute's been settled. And you see where I'm going with this. So the title dispute is in that federal court to be settled. So the immediate possession needs to be connected to the title dispute. And once they file that, then you can take a file stamp copy of the notice of removal with a file stamp copy of the challenge of jurisdiction. But now it's file stamp for federal court. So this is how you get state court stuff in federal court. You file it as an exhibit, and you take your notice of removal You take it over to state court and you let them know that the case has been removed and connected to your title dispute that you have filed in federal court. And I would ask them if you could please send my file over to federal court for me. Thank you very much. That easy. I know. It really is. See, we've been taught by these attorneys to make everything complicated. And the more complicated you make it, the harder it is. Right. But when you keep it complicated, where there's no arguing and crap, things look a little bit different. So removing the eviction process and connecting the eviction process to your lawsuit, to your title dispute, is the key to getting control of the eviction process and the non-judicial foreclosure. Now, one of the things that you guys have to remember is the non-judicial foreclosure is done outside of court, right? So how do you defend yourself against that? The attorneys will tell you, well, you must wait until the foreclosure is done, and then I'll be glad to help you. Yeah, I'm sure he will. I'm sure he will. So one of the things that I tell people is it doesn't matter if you're talking to me or if you're talking to an attorney. The thing that they're telling you to do should make sense to an average person. It should make sense. So when someone files a lawsuit against you and they're trying to take your house, should you wait until you get to court? Oh, wait, you're not going to get to court until you get to the eviction process. So wait a minute, I don't really want to wait till they sell my house before I try to go to court, or wait till the eviction process when they're talking about selling my house. So why would you not just go ahead and file your lawsuit against them for wrongful foreclosure / breach of contract in federal court? Why would you wait until they're done stealing your stuff and kick you out on the street before you fight? And remember, that advice is coming from the attorney. The same attorney that's you're paying to help you now, that's not helping you and wants to help you after they get done taking your shit. Oh, we'll help you when they're done violating you. I'll be glad to help you until you run out of money. And when you run out of money, you're going to be on your own. Or if it gets too hot in the kitchen because you ain't doing what I'm telling you to do, then I'm going to skate out the back door and leave you on your own. So the goal here is to blow up the state case with your jurisdictional challenge with an affidavit and use the fact that the attorneys are in default to demand summary judgment in your federal lawsuit. That's slick as hell, ain't it? That's slick. Attack the case using a jurisdictional challenge, or even if you don't have jurisdictional challenge and you bought the package, attack the case using the jurisdiction challenge. The jurisdiction challenge and the jurisdictional challenge with an affidavit are two completely different documents. And if you've worked with me, you'll know that I'm going to make you say the whole word for each one. Because when you don't, and you say, well, I'm talking about the jurisdiction, but you're really talking about the jurisdictional challenge with an affidavit, there's a huge difference. And if I'm going to give you guidance or coaching, then I need to make sure that you understand what I understand what you understand, and we're both on the same understanding. We both understand. Okay, you got it, right? Okay. I get a little carried away sometimes with the understanding. So that's important. And that's why I'm going to make you say the whole thing. Because the time that you don't, and I think you're talking about something that you're not talking about, and I give you the wrong advice, then I'm going to be looking like an attorney. No, I would not look like an attorney. Maybe a really good attorney. I don't know if there really is. Okay, never mind. Let me stay focused. So you can use the fact that they failed to properly respond to as evidence in your federal lawsuit. I would. Because if they can't respond they can't properly respond to your jurisdictional challenge on the state level, they're not going to be able to answer any of that stuff on the federal level, because you're going to go to court on the federal level attacking the same thing that they can't explain on the state level. You need to use what's working, run their plays against them. Cost them money, make the attorney have to hire somebody. And see, that's the thing people don't realize. When you add the attorney to your lawsuit as the number one defendant, that attorney now has to go and hire somebody else to represent them, because they're not allowed to represent themselves. They're not allowed to litigate a case they're party to. And most people don't realize this, but they're not allowed to represent the law firm that they work for in court. Now, the way we do things, you're going to jam them up so they can't find anybody else to represent them, because once the other attorneys find out that you're going after them for breach of contract and wrongful foreclosure acting as a third-party debt collector, they're not going to want to help them. And in my opinion, the reason this works out so sweet for us is because the other attorneys are doing the same shit, and they can't go into court trying to defend somebody if they're dirty also. So now the judge has to let them proceed in court, even though the rules mandate that they can't. And so that's a nice situation right there to hang your hat on for your appeal, to give you time to get your documents filed against the judge. Your magistrate judge reconsideration package has all the documents that you need to file against the judge for your objection, your notice of objection, and your recusal document, motion to recuse, and notice of claim. All that stuff is in there. So the goal is, whenever you get violated and they're blocking you from getting into court, you need to address it and hold whoever it is that's trying to block you accountable. That's how you need to roll. Because when the judge violates you, if you don't address it, they will continue to violate you until they have your butt kicked out of court. And I got people in the Facebook page. I've told them, you got to address it. You got to attack the judge if the judge is violating you. The judge does not have immunity if the judge is not following the law. So that's the way we roll with that. Now, the non-judicial lawsuit package, I added the package to it, the motion, the notice of reconsideration package that has all the stuff in it you need to smack the judge in the face. I added that stuff to both of the lawsuit packages. So the non-judicial lawsuit package at this point, if I remember correctly, has like 24 documents in it. Now, don't freak out when you open it up and you see all of those documents, because you can only do one step at a time, one document at a time, one step at a time. And the best thing to do, if you can understand the purpose of the document and why you're following it, then you will understand the order in which they need to be filed for the most part. And most everybody thinks it's the same, because we're not addressing stuff that, when you get in my program, we're not addressing the stuff that you were addressing in state court and all of that stuff, okay? You don't want to connect any of the stuff that you were doing with state court with my stuff, okay? Because if you do, they'll argue that stuff, because that's what they want to talk about. They don't want to talk about this stuff over here. So if you connect the poop with the good stuff, then the good stuff is going to smell like poop. That's the best way I can put it. And I tried to make it nice. So, and a lot of times people have a hard time with me when they call me and they're trying to talk to me, and I'm telling them, look, I don't need to hear everything that happened from 2009, because that's not what we're going to talk about, okay? What I need to hear is from the end, going back just a little bit, to make sure that I know if you need judicial or non-judicial, if you are in a trust or not in a trust. So those are things that are more important than all of the things. And then people need to realize that it's not the lender. The lender has not signed any paperwork and any of the foreclosure paperwork against your property. It's not the lender. So if you still think it's the lender, or you want to sue the lender, you're wasting your time, and you probably should start packing your stuff and getting secured in the end, because you're not going to be anywhere close to where you want to be. If you go into court arguing the banking system, you're going to struggle. Okay, what you need to address is the fact that what you need to address is the fact that the foreclosure statute does not have the necessary elements to be considered a valid law, and therefore the court does not have jurisdiction. Yep, check. Could it be that easy? Check yourself. Okay, each state constitution mandates that for something to be a valid law, it has to have an enacting clause, it has to have a title, and it has to have a body. Okay, without those things, it's not considered a valid law. And if it's not a valid law, it's not something that can give the court jurisdiction to take your shit. End of the story. Okay, that's the main thing that you want to address, and that's the same for everybody. Everybody's state constitution, well, except Georgia. Georgia's state constitution doesn't mandate that, but the Supreme Court and the federal constitution both do. So either way, you're still at the same place. And that's one of the most important things. When people get to court, they listen to the judge and attorney are working together, and they get you off of what got you in the court, okay, which was the documents and the stuff in the documents, and they get you to start talking about the payments. They want to talk about the damn payments. So I'm like, well, wait a minute. A lot of shit happened before you got to the payments, okay? And all that stuff that happened before you got to the payments is what screwed you over. Okay, we need to talk about that. I ain't talking about the payments, okay, because all the payments are illegal. But they want you to talk about the payments. And then they want you to come and to their office to take a look at a copy of the promissory note, or excuse me, the original promissory note. I'm like, well, wait a minute. Why the hell would you need to go to their office? That shit is supposed to be filed, a certified copy is supposed to be filed in the court to start the foreclosure proceedings against you. And they have to have a witness. Oh, wait, there's no witness. Yeah, they have a lot of problems. And that's what we address. We address those problems of the fraud that caused you to be in the situation you're in right now. And that's why we don't have to look at all of that stuff and talk about the lender. And I have people that come into the page and they want to talk about the lender and the lender this and the servicer and all of that. And they get kind of pissed off when I don't have time to talk about all of that stuff, because I already know it ain't about none of that. It's not about any of that. What it's going to be about at the end of the day is going to be about you defending yourself and attacking the judge that's blocking you from getting in court. That's what it's going to be about. Now, we've been learning how to cut to the chase, and that's what we're doing here, because we don't have time to be playing around. So if the judge is going to help them, we're going to cut to the chase and set up a program to hold the judge liable for helping them violate you and create an unfair advantage. And that's what the new package is about. So the new notice of claim against the judge for taking jurisdiction, for taking authority without jurisdiction. Now, this is specifically written up for the judge dismissing your lawsuit without judicial authority and taking charge without jurisdiction. Now, it's written up for them dismissing the jurisdictional challenge with an affidavit. Now, it can be modified or personalized to fit any situation where the judge dismissed your claim without jurisdiction. And in most cases, the judge dismisses your stuff without jurisdiction. And I'll tell you why. And most people don't realize this. So, in most cases, you file your stuff, the clerk or the district judge looks at your stuff, and if it's hot, they ain't trying to handle it. So they'll send it down to the magistrate judge. And the magistrate judge will review it, and then the magistrate judge will write a report and send the report back up to the district judge to dismiss your shit for a failure to state a claim under Rule 12B. Now, I put out 2 videos on how to do that. It took me a week to research it, and I put out 2 videos on how to do that on the website. So just go to it and type in a search bar, how to state a claim. And I review it and go through it in great detail. And I also have cheat sheet notes on what you need to look for when you're stating a claim. So the first thing that happens is the judge to dismiss your or write a report to dismiss your lawsuit for failure to state a claim under Rule 12B, 12B6, 12B6A or something, and send it up to, and then so now the district judge will take your lawsuit and dismiss it for failure to state a claim based on the magistrate judge's report. Now, most people are, the magistrate judge, no, you just got screwed a whole bunch of times, okay? Because number one, the magistrate judge has no jurisdiction to be involved in your case without consent from all parties. Search it. If you don't believe me, search it. Punch in magistrate judge consent form in your state. And more than likely, you'll pull up the website that shows the court website or whatever, that shows the form that you have to fill out, that has to be filled out, consenting for the magistrate judge to take jurisdiction in your case and make a ruling. That's the first problem. Okay. Well, the first problem is that they sent it down to him. That's the first problem. Second problem is that the magistrate judge made a determination in your case without consent, which means you did not have judicial authority. And then the third problem is the district judge dismissed your stuff based off the magistrate judge's report. I know most people don't get. Okay, so the magistrate judge's report, that's an administrative procedure, not a judicial procedure. If it was a judicial procedure, then it would have been dismissed based off of facts of finding and conclusions of law. That's what the judge is supposed to put together to verify why they dismiss your shit. But they don't do that. They use a report. So your stuff just got dismissed based off of an administrative procedure report. Most people have no idea. That alone is enough to sue them. So for me, my program is anytime you have an opportunity to sue them, we need to be jumping on it, because it ain't going to be fair for you to wait until the judge rules in your favor. Oh, hell no, that shit's never going to happen. So remember, we're learning how to cut to the chase. When a judge violates you and helps the attorney steal your home, you must hold anyone liable, including the attorneys, that's getting in your way of having your day in court. Now, in this new lawsuit package, you'll need to file your notice of claim against the judge who illegally dismissed your jurisdictional challenge with an affidavit. Remember, the notice of claim is something that they're not required to respond to, but your goal is to use it as leverage and try to get them to either let you through, let your lawsuit proceed, or offer a settlement, or talk to you about something. Or, if none of those work, then you might need to just go ahead and file your lawsuit against the judge if the judge is blocking you. Because at the end of the day, it don't really matter who you sue as long as you're suing somebody. So that's the way that rolls. Now, we're about to step up. This package has a notice of claim specific for the judge violating you by taking jurisdiction without judicial authority. The notice of claim is also the claim. You just take the word notice out. I like to show them exactly what you're going to be bringing to the table right at the gate, because the whole idea here is stay the hell out of court. So when you're ready to file your notice of claim, if you need to, then all you have to do is just remove the notice, and now it's your civil claim ready to go. And if you want to file in state court as a notice of claim and the supporting documents to regain control of the case, and that's really what this is set up. This is set up to stop the process of the state court case and to gain control and give you a little more time to get your lawsuit, your title dispute. Remember, you want to get your title dispute filed in federal court to block the immediate possession issue, because they're going to try and jam you up with their little immediate possession issue. So once you jam up the judge, you will have time to get your lawsuit filed and give yourself a fair chance to fight for your property. Now, this package is on sale for it's half price at $200 and contains 6 documents. So that's about like what, $33.33 a piece or something like that. So it contains the objection and notice of claim document. You will get a motion to strike the judge's order. If the judge has already put out an order against you, you get a motion to strike the judge's order. And you also have a motion to recuse the judge. Now, I've added in a couple of documents to verify your state citizenship. Excuse me. I added them in to the document and to the package. So you'll get the United States of America affidavit of state citizenship. That document you will use to verify your state citizenship. And once you verify your state citizenship, then the court does not have statutory jurisdiction over you as a state citizen. And that's important because you can use that alone to challenge jurisdiction of the foreclosure. And you also have entry of appearance document. The entry of appearance document is set up to for people who had attorneys. And people who had attorneys, people who've had attorneys are trying to throw them under the bus. And what happens is when you come to the table with my fire, okay, their attorneys, even though you tell them they fired, they still get in there and help do stuff and help control the documents that are filed in the court to help protect the court and all of their buddies. So this entry of appearance specifically puts all bar members, including the clerks, on notice that no documents are to be added or removed from your file or your case without your written consent. And that's pretty powerful. And the 6th document is the civil cover sheet answers. Now, I put this document together so people can answer their questions in the civil cover sheet a lot easier. The best thing to do is to pull those things up on your computer and print them off. Those forms, print them off at home and have them all filled out by the time you, mail them to federal court now. I used to go down there and file your stuff, but things are kind of different now. And when you're mailing your stuff in, you need to make sure that you mail it in a manner that forces them to sign for it. We've had situations already in the group where they tried to put Shamel Maxwell, they tried to put her dad's stuff in the basket and wait a couple of days until after her dad's property was sold, and we jammed them up because here's the deal. When they sign, that is the day that document should have been posted on the website to protect your interest. And if they park it in a basket and say they lost it or whatever, then that person who signed is the one that we added to the lawsuit. And we did an amendment, and we added them to the lawsuit because on all of my lawsuit packages, we have the right to reserve. We reserve the right to amend. We have the right to reserve. Okay, so I sound like I know what I'm talking about, but I do. I just don't know how to say it because I'm thinking, okay, never mind. So remember that. And let me check and see if anybody has any questions today. So, John, if you want to talk to me about your stuff, John, you can meet me in the group because this session on the stream is educational. And it's not really the session where we're going to talk about everybody's stuff unless there's something specific that we want to talk about. John, I sent you a request in the group and asked you to call me, and you never did. I sent you another request and I haven't heard from you. So if you want to contact me about your stuff, we can talk about it in the group. I'll be in the group when this stream is over, and you can talk to me about it in the group. Does anybody have any questions about the package? I'm going to screen share the package with you guys, or the product page, so that you can see it. And then I'll leave a link for it in the stream. So this is the product page on my website, and I'll give you a chance to read that if you want to read it while I copy and paste a link. in here to the group. Hey, Ollie, welcome to the group, buddy. Now, I did a little bit of write-up on this, so I wanted to make sure I figured some people are going to be buying it that haven't seen the video yet. And when you guys invest in a document, you should go to the website and find the video for that document so that you can watch the video. I'm going to talk with my my tech man to see about how I can put a video in with the lawsuit package in the file that'll get sent to you when you purchase the package and the package downloads. I got to check and see if I can download the video also. So that's one of the things. I think you're listening to me now. So, hey, John Smith, that's my question. I need to know if I can add a video to my package on my WordPress site. So when people invest in one of the lawsuit packages, they will automatically get the video that they need, the instruction video for that package. So we'll talk later, buddy. Now, I post a link to this. Oops, it looked like it errored. Huh. Well, we'll try again. Let's try it again. I said, I ain't know. Thanks, Ollie. Okay, let's see if we can post that link in here again. Yeah, I spent a lot of work, a lot of time studying this stuff and figuring out how to kick these attorneys' butts because they piss me off. So that's my that's my motivation. They piss me off. They treat me like I was stupid and piss me off. So now I'm teaching other people how to piss them off. And I enjoy my job. So if you guys are facing, in this situation, if they dismiss your jurisdictional challenge with an affidavit, this is the package that you need. And I put it on this. I'm going to post it on the site. Right now, I've posted the link here and in the Facebook page and on the YouTube YouTube video. And I'm going to post it on my website as well, but I haven't got around to that quite yet. So yeah, thanks, Ollie. I hope this information has helped you guys. The non-judicial foreclosure situation is a pain, and they don't give you much time to do anything. And usually, what happens is they tell you, we're going to work with you. Don't worry. I'm going to call my people. We're going to see if we can do a loan modification and all this stuff. And all they're doing is running you out of time because they already know that you're struggling or you wouldn't be behind on payments. Okay. And when you do loan modification, all they're doing is using that whole process to disqualify you. Because once you expose yourself and you give them your financial information and they find out that you have more money going out than you have coming in, then it's a problem. So why would they want to give you a loan modification if they know you're struggling and you might not be able to pay in 2 months or 3 months or right now? They're better off taking your shit so they can resell it again. That's what they do. So they ain't interested. If they was, and this is what I tell people, if they was interested in helping you, you wouldn't be in trouble. They would have helped your ass a long time ago. They ain't interested in helping you. They want your stuff because it's their scam. And the property tax, eliminate property tax lawsuit package, that addresses some serious issues. The eliminate property tax lawsuit package, I had to use eliminate property tax to get people to even look at it because they don't understand. Okay, that whole package is set up to help you get control of your deed. Okay, and if I said I got a package to help you get control of your deed, people will tell me, oh, I have control of it. It's registered over there. They're watching it real close. Yeah, once it's registered, they start charging you property tax, and people don't realize this. The first illegal lien that was put against your property was put on your property after your property was registered in the county recorder's office. And I bet no one knows what that first lien against your property was. What was the first illegal lien put against your property? Most people probably don't know. I'm going to give you guys a minute. Does anybody know what was the first illegal lien filed against your property? It's a trick question. Well, I'm going to tell you. The first illegal lien that was put against your property after the bar members tricked you into allowing them to register your property in their office. The first illegal lien that was put against your property is the mortgage lien. The mortgage lien was illegal when they put it against your property because your property was paid for with your signature. Your signature on the promissory note is what generated the electronic credits they're saying was the loan that they gave you. Now, I know everyone that's all crazy. Look, I box and I play football. Those are two things that real smart people don't do. I'm just keeping it real, okay? So I have to keep things simple. And this is the way I see it. And this is what I tell people these attorneys, when they're in my face, when I'm posting stuff on here's the thing. The lien, if you're the owner of property, before the property can be liened, a lien can be signed against the property, all of the owners will have to be present to do that. Correct? Correct. So the fact that the lender accepted your signature on the mortgage note on the lien against your property proves that you own the property free and clear. Or some other people would have had to be there to sign. Think about it. You guys tell me if I'm crazy. Because I like to keep it simple. And when it's simple, there ain't no room for all this bullshit. So, John, you can call me tonight too. If you want to talk about your situation, I'll be in the group, or you can call me. I already gave you an offer to call me. That's still open because your situation is not the same as everybody else's, because things didn't get done like in a timely manner. And then when they responded, you have to reply to their responses. If you don't reply to their responses, then they just mow you down. So if you want to contact me, you can. And I'm going to check out right now, and I will talk to you guys in the next stream. I hope this, let me go ahead and close up my screen share. So I hope this has helped you guys out, and I will see you guys in the next video.